Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna PC, immigration.com. Welcome to our bi-weekly, once in 2 weeks, community conference call where everyone is welcome to participate. But you would have heard the disclaimers when you logged into the conference. This call does not create an attorney-client relationship and information is presented as is. With that said, let me just make sure you folks can hear me okay.
The conference is now in conversation mode.
We can hear. Okay, good, excellent, thank you.
The conference is now in presentation mode.
Let me begin first with the frequently asked questions. There are certain questions I consider are being asked a lot, so I mark them as frequently asked. The first one is from Madhuri, and this question and related questions were asked by a couple of other people as well, so I grouped them all together. This is regarding I-485 pendency and using employment authorization, etc. The first question is from Madhuri, who's a registered nurse present in the US with an F2 stamp. Husband has 2 more years to go on I-20, so he's still in school. Employer sponsored her green card, and she's received her EAD based upon the 485. But both my I-140 and 485 are pending. But the employer wants her to start even though the I-140 is pending. Madhuri, the only time I hesitate to use the employment authorization is when I have any doubt about my I-140's merits. If I am concerned that my I-140 might get denied, I would be reluctant to use the employment authorization, because use of the employment authorization when the 485 is pending puts you out of any current visa status that you have. So if you have an H1 but you use an EAD, you are no longer on H1. You are on what is called authorized period of stay, which is less than status, but it's definitely legal. If you are on F2, the moment you use the EAD, you're no longer on F2. To revive the F2, you will have to step outside USA and come back with an F2 visa. I have always found this to be troublesome, and maybe someday we will challenge it in court. This entire idea about there being a huge distinction between authorized period of stay and status, etc. I'm happy to report that we have challenged it at least once 2 weeks ago, and the government settled with us. Slightly different circumstances there, but the same concept. The idea was that there was an H1B extension pending. Original H1 expired. The individual moved on with an H1 transfer to a new employer. They approved my transfer, but they declined to give my client the status because they said, well, his last case is still pending, so he's not in status, he's an authorized period of stay. And I said, that's nonsense. That should not make a difference because the regulation doesn't read like that. Now, grant you this, that the regulation is worded a little differently than most other regulations. So I had that going for me. But when we explained the regulation to the US attorney in our lawsuit, they were only too keen to settle the lawsuit. So someday somebody should challenge this. But until it does get challenged, the fact is, if you use your EAD while you are in 485, you are no longer in your original status. To convert back to that status, you have to step outside and come back with that visa or any visa. Okay. So what would I do if I were in your situation? First thing I would do is I would check with my lawyers. How strong is my I-140? Is there any chance that I could get into trouble with my I-140? Nurses' cases are fairly easy and fairly predictable. Why? Because you are under Schedule A, you don't have to go through labor certification. So things are a lot easier for you. But you still are subject to the priority dates of your home country of birth. So I would want you to have this assessed. Frankly, an F2 visa is not the greatest get in the world. I would rather have you on H1 or something stronger. I'm not sure F2 is the best visa. So all in all, my inclination is to start using the employment authorization. And if you are a registered nurse, which you say you are, and I have no reason to doubt that, you are a registered nurse, and if you are working with COVID patients, or even otherwise as a healthcare worker, there might be some options for your visas, etc. Nothing that I can think of right now. I'll give you that, but it might be something to keep in the back of your mind. I would start using the EAD if my I-140 is on solid grounds. So that's the first answer. And if you use that EAD and the I-140 is denied, should I leave USA to avoid unlawful presence? Well, that's a difficult question to answer. First of all, remember, less than 180 days of unlawful presence causes you no permanent damage, but we would like to avoid that situation where possible. Also, there are special kind of H1s available for nurses who work for certain hospitals, and they are not subject to the quota. You should look at that. You should also look at an H1B. I strongly recommend looking into H1Bs. You should also look at H1Bs, which are for university hospitals. There, you will not be subject to the H1B quota. So as a fallback device, having an H1 is a lot better than having an F2. So yes, I would go ahead and start using my EAD if my I-140 is strong and solid. Radha had derivative questions again on employment authorization under 485, etc. She or he says, I'm on H1B past 16 years. Priority date is current. Porting now to a new employer, filing a 485 in a couple of weeks. H1 is good till October of this year. If 485 is in pending status, can we apply for 1 year H1 extension? I believe so, Radha. There are two sections under American Competitiveness in the 21st Century Act. I think section A and C. A is the one that gives you 3-year extensions, I think, and C is the one that gives you 1 year extension. So if I remember the law correctly, I have to review it real quickly. But if I remember the law correctly, the way this works is that even if you are not entitled to 3-year extension because your priority date is current, you should be able to still get a 1 year extension. If for any reason I-485 is denied or rejected, can I reuse my priority date? And the answer is theoretically yes. But the question is, what would be the reason for the denial? That's a little difficult until we know that for sure, because there are some kinds of denials that are based upon an I-140 revocation. If the I-140 is revoked, it becomes questionable whether you can maintain your priority date. Can I get, as usual, my H1 extensions after green card is denied? The answer is no, unless the I-140 is revoked and that's the ground for your 485 revocation and you have filed an appeal against the I-140 revocation. If I lose my H1 because of 485 denial, do I have to apply for new H1? And the answer is no, but the problem is you may not have any means of extending your H1 if you've already used up the 6 years. If H1 extension is denied, can I transfer my H1 to new employer? The question is not transferability. The question is, do you have any time left? Can I reuse the priority date? I've already answered that question. If we get green card EAD, can H1 person work on green card EAD? Or H4 person? The answer is sure. Do they have to step outside the country and re-enter on H4 visa? Yes. As I discussed in the question asked above, I think it was Madhuri who asked me the same question. Just like in F2, if you want to revert back to F2, H4, H1, any of these visas, and you have used your EAD or the 485 is denied, you would have to step outside and come back on that visa. And I also explained that I think it's a questionable legal supposition, and I think it should be revisited by the government. Okay. And now from Kumar, again, related questions about using EAD I-485 EAD. So Kumar has been working with the same company 4 years. Future green card based case processing with company B, 2009 priority date, downgraded from EB2 to EB3. During this process, I've applied for a new I-140 with existing perm, got my EAD in EB3 also. I am unable to use the EAD as my I-140 in EB3 is not yet approved. I filed this I-140 in EB3 during December 2019. 19 months they've been sitting on it. My God. Now that I-140 in EB3 is not yet approved, we have raised you should file a lawsuit. I really believe so. All these congressional inquiries at some point they have to stop. No question in my mind. Go ahead and sue them. My EAD is expiring in December. Do you think, in worst case, if EB2 date becomes current, can I refile my AOS in EB2 category? You don't have to refile. You just have to request the government to tag your EB2 I-140 approval to your current 485. They used to, at least this is not a legal technical term, we call it interfiling. So the existing 485 is interfiled to the EB2 approval. You don't have to refile the 485. My EAD is expiring in December. AP has validity till next year. Can I ignore applying for AP? No, apply for both. You already paid for them anyway. So apply for both. Okay, so I answered questions from three different sets of people, for Madhuri, Radha, and Kumar. Anybody has any follow-up questions? Press star 5, please. Any follow-up questions on what I discussed? Press star 5. No new questions, just follow-ups, please. Okay. Now we have one. Area code 832. Where are you calling from, 832?
Hey, Rajiv. This is Kumar.
Where are you calling from?
Yeah, thank you, Rajiv. I'm calling from Houston.
Houston. Yes, Kumar. Go ahead. What is your question?
Yeah, thank you, Rajiv, for answering the question. So right now, I have used the option of Ombudsman. I just recently raised a request with the Ombudsman service. In your experience, what is the probability that
I'm not going to answer that. I'm not going to answer that question. There is no way for anybody to sit here and conjecture about the possibilities and the probabilities. I can tell you what you should do next. If it were my case, I would be moving the court. I would not deal with the government anymore. Okay?
Okay.
Good luck.
Okay. Thank you.
You're welcome. Okay. Then we move on to the next frequently asked question. And these are issues related to H4 employment authorization. First one is from Kumar and then the second was from Preeti. I combined the two. Kumar wanted to know if H4 EAD can start any business. The answer is yes. In fact, yesterday I had a request from someone who wanted an opinion whether H4 EADs can do business, and they wanted to know what we would charge for giving an opinion. And I said, look, if you just want a recording, I'll be happy to do it free of charge. because it takes me only 30 seconds. Just post it on the conference and I'll answer it. But if you want us to give a written opinion, that is a lot more work, because written opinions have to cite to statutes, they have to cite to regulations, and there's certain way that a written opinion is drafted. It's almost like a letter from a CPA, which has to go through certain processes. So short answer, you can start a business, any business, 10 businesses if you want, no problem. Only issue is, what if there is a gap in your EAD? You won't be able to run that business, then somebody else should be able to. So that's the only practical difficulty. Legally, there is no problem. You can do whatever you like. And then Preeti wanted to know, I am working full-time on H4EAD. I got another job, a full-time job with company B, and I can do both jobs. I'm planning to work for both companies. Is that doable on H4EAD? Absolutely. You can have 1, 2, 3, 10 jobs or no jobs at all. It's up to you or your own business. It's kind of interesting, isn't it? That you have a lot more freedom on H4EAD than you have on H1. H1 has so many restrictions, whereas H4EAD has few. Suppose my H1B gets approved with company A. Once H1B gets approved, do I need to leave company B? Absolutely. If your change of status to H1 is approved, let's say it's effective October 1st, on October 1st, you no longer have an H4 and you no longer accordingly have an EAD. So you are only authorized to work under H1B, yet the approval. And remember, I just said that there are a lot more restrictions under H1B than there are under H4EAD. Also in the W4, do I need to specify that I'm doing 2 jobs? I have no clue about that, ma'am. That's a tax issue. You should be talking with the CPA. And by the way, another thing I want to make clear is that you could even be working on a 1099 as an independent contractor. If you have an H4EAD, you could do business, you could do multiple businesses, you could not do anything if you want, and you could work as an independent contractor on a 1099. Okay? These are the H4EAD's issues for today. Press *5 if you have a follow-up question on this. Please press *5. Area code 571. 571, go ahead. Where are you calling from?
Hi Rajiv, this is Preeti. I'm from Virginia.
Gee, you're my Padosi. Tell me.
Like you already understood that I am as of now working for 2 companies basically, and the reason I'm working for 2 is because the company A who has filed my H1 actually, I am not sure whether they are going to keep me for a long time or not. That duration is somehow small. So that is why I have to, go for another one. So, I understood the question that you answered, but can you just let me know, what happens, if they release me for now, right? But the H1 has already been in application, and I am only continuing for the company B, and, the H1 gets approved.
Yeah, you have a problem. Then you have a problem. Because you are like a rider of 2 boats who's left in between the 2 boats.
Right.
Okay. So if the H1 gets denied, you're no longer on H4 because the change of, not denied, sorry, abandoned. So they got the, H1 got approved, but you don't have a job. That means you're no longer on H4 if the change of status is approved, and you no longer have an H1 job, so you are out of luck. And I would say you would have a 60-day grace period within which to get another H1B filed from another employer. One thing though, I would make
find another employer who can transfer. But if I'm working for company B and they agree to basically transfer me onto H1, that would work, right?
That would work fine. The only timing that you would have to adjust is make sure that your H1 by company A is not withdrawn or revoked before October 1st.
Before October 1st, okay.
Hanji. So let's say that...
As of now, I haven't received for H1 because mine was filed later in June and only just 2 days back I just received my receipt number. Everything is going a bit slow on the H1 actually.
Right.
So it's very slow.
You should tell them not to revoke if they are going to revoke before October 1st, because their liability to pay you under H1B doesn't kick in until October 1st. So they could send a revocation on October 2nd, 1 day pay. What is the big deal?
Okay. I'm just assuming that everything remains fine, but I was just trying to understand like what happens in these kind of scenarios. But thank you so much.
You're welcome. You're welcome. Good luck. Okay. So those were my H4 EAD questions. Yeah, and here's another one from Nikita that I have answered a couple of times before, but I'll answer again. It's important, guys. See, H1B process requires 1, 2, 3 steps. The employer has to take 3 steps and they should take a 4th one also. 3 are required by policy. First, they should inform you no longer have a job. So information about your termination should be given to you. 2, they must offer you a one-way ticket back to your home country. And 3, they must inform USCIS to revoke the H1B. If they miss out on any one of the 3, you can file a complaint against them with the Wage and Hour Division and ask for back pay till the time they follow through with all the 3 processes. The 4th one they should do is also revoke the LCA. So if they don't do that, one of the things, Nikita, what you could do is file a complaint against the employer with the Wage and Hour Division of the US Department of Labor. They make you fill a form WH4. You can actually call them. I was talking with one of their officers, the Wage and Hour Division officers. They are the ones who come and investigate employers for violation of H1B laws. And we had an audit for a client, and we were in constant touch with the Department of Labor. She was a very nice person, and we just got to talking, and one of the things she told me was that they were, even during the COVID times, manning all their calls from the public. So if you call them and you say, look, I have a problem, what should I do? They are bound to give you pretty good legal advice because they know their policies and they know their rules. So they'll have you file I think it's called a WH4. I think so, a WH4, Wage and Hour Division Form 4. So WH4, what that does is, until the employer does all the 3 things that I mentioned to let you go, government will make the employer pay for the entire time period, and you don't have to spend a single penny. Number 1. Number 2, based upon the complaint, if for some reason you go past the 60-day grace period, you can always argue that I was never fired, I just didn't get paid. So therefore I'm not out of status and my 60-day doesn't begin to count until all 3 things are done. Just something to keep in the back of your mind. Although I prefer you file a B2 within that 60-day grace period, or an H4 if your spouse is on H1, something to keep you in status. Yeah, the 60-day grace period works like this. The new employer must make sure that your H1B transfer application is received by the USCIS within the 60 days. So the LCA should be done, the package prepared, and USCIS should receive your H1B transfer within 60 days. Otherwise, you'll be out of status and you'll have to go outside USA for visa stamping, pandemic or no pandemic. Also, you remember there's a proclamation that will stop you from coming back at least before December. So I would avoid that situation. Make sure you remain in status or at least file a B2. And one of the interesting points that comes up sometimes, and I mentioned this before, will I be able to get a change of status from pending B2 to another H1? And I would very strongly argue that government should give it to you because their understanding of the law and their application of the law is inappropriate and illegal. *5 if you have a follow-up question. *5. Press *5. Okay. Area code 203. I think that's Connecticut. 203, where are you calling from?
Hi, my name is Kanchan Shah. I'm calling from Charlotte, North Carolina.
Oh, okay. Yes, Kanchan.
My question is actually, I changed an employer. I used to work until last month in California.
Ji.
I changed an employer. My H1 transfer is, my petition is transferred and joined new employer in Charlotte.
Mm-hmm.
But my old employer hasn't paid me for a whole month of June, and my last day was July 8th.
Ji, you should definitely,
I don't know
Kanchan,
what to do.
you should definitely file a complaint with the Wage and Hour Division. There are two reasons for that. One, you get paid, and two, it creates a good defense against any allegation of being out of status.
Okay, I'm not out of status. So basically, what happened is my H1 got transferred and approved with the new employer as soon as I joined. So it's been approved from 10th of August. So it got approved. I gave the notice of 15 days after my transfer LCA was filed by new employer.
Okay.
So I waited until I got the receipt.
Okay.
So I'm not out of status, but the only thing is that I didn't get paid for a whole month. You
should definitely get paid. Why should you not get paid? So go ahead and file a complaint. The government will get your money for you. Okay.
Department of Wage and Labor, right?
Yeah, not Wage and Labor. Wage and Hour Division, WHD, Wage and Hour Division of the U.S. Department of Labor. Okay?
Okay, great.
Good luck.
Thank you.
Good
Thank
luck.
you very much.
You're welcome. And Kanchan, just as a parting comment, it's not complicated. It's not rocket science. It's easy to do. Next question. This is another interesting question. Sarah said, once my H1B transfer is approved, what is my deadline to join? And the answer is there is no deadline. Let me explain to you the way the law works. You are working for employer X. Your H1B is good for another 2 years, let's say. You apply for a transfer to employer Y, but you want to continue working with employer X for 1.5 years. Can you do that without losing your second H1B? Sure. Yes, you can. The reason is, if the employer Y is letting you join late to accommodate your convenience, it is legal for them to do so, and you still maintain your H1B with employer Y. If, on the other hand, you want to join and the employer Y says, no, I don't have a project for you, that doesn't work. If you are in the USA, they have 60 days to either employ you or to fire you and revoke your H1. If you are outside the USA, they have 30 days. If you have come from outside the USA, they have 30 days to put you on their payroll or to let you go. So the rule is, to accommodate your convenience, there is no time limit. To accommodate the employer's convenience, there is a 30-60 day rule. However, the way the rule works is also this. Within those 30 or 60 days, let's say on the third day of that 30 or 60 days, you call the employer and you say, hey, listen, John, I'm here, I'm available to work. They have to put you on the payroll that day or the day following maybe. But definitely they have to put you on the payroll on the earlier of the time allowed or the date you report for duty as willing to be able to work. So the 60 days is not a grace period. It is an up to period. If you report for duty earlier, they have to start paying you right away. I hope that makes sense. *5 if you have a follow-up question. *5. Okay, so these are the questions that I thought were frequently asked questions. Now let's get into our regular questions. The first one was about a DV lottery, and there's so much delay. They were saying, what should I do? Because everything is just getting delayed, and should I proceed to write a letter to National Benefit Center or go through Congressional Immigration Liaison? Look, I'm not an expert in DV lottery, but if I remember correctly, your green card must be issued within this fiscal year, otherwise you lose it. So you don't have a lot of time. You might want to consider filing a lawsuit because the fiscal year ends on September 30th, right? So if I were you, I would consider filing a lawsuit. *5 if you have a follow-up question. *5. Okay. Next question. Contact GS has a BALCA appeal pending. So when the perm is denied, you file a BALCA appeal. It's been pending for a couple of years. They've been getting an extension. First of all, I'm not sure that's the smart move, because when we file an appeal, it is just to make sure that we can get another green card started for you. So we time it so that BALCA appeal is filed, we got 1 year H1 extension beyond 6 years, immediately we file a new perm and withdraw your BALCA appeal. Well, withdraw your BALCA appeal and file a new perm, and then from there on the new perm becomes the basis of further extensions. So it can be timed, and that's what should be done. Why waste time waiting 2 years? Anyhow, what happens to the already approved H1B extension? I don't think they can take it away. Now, I have looked at the law many years ago, and I thought that the government, if they wanted to be really adventurous, could try to come back and revoke the H1B, saying that, well, when we gave it to you, you were entitled, now you are not. I don't think they would succeed. Why? Because on the date you got the extension, you were entitled to it. Later on, things changed. I don't think they should be able to revoke your H1B. I don't see any other implications. If it is timed correctly and delicately, you should be fine. Your lawyers can double check and make sure that that they feel comfortable with being able to defend government's attack on your H1B extension already given. Personally, I don't recall being overly alarmed with it. So I think you'll be okay. *5 if you have a follow-up question. *5. Okay. Oh, there is a question. This is from California. Yeah, California, go ahead. I can hear you.
Hi, Rajiv. I have a follow-up question on this one.
Of course.
Say that my new perm is ready after revoking the BALCA.
Sorry, you're breaking up. You're breaking up. Hang on. You're breaking up. You said your new perm is what?
Yeah, so the BALCA perm, my employer is trying to revoke it and then file a new perm. So in the case that the perm remains pending for 365 days, would I get an extension, H1B extension?
Absolutely. Okay, I'll take another extra second to explain to you how we time it. So you know that you can apply for an H1 extension 6 months ahead of time, right?
That's right.
Okay, so what I do is, I file the BALCA appeal, I get my 1 year, and in the meantime, I've started recruitment for my second perm application. So I make sure that I get my second perm, my BALCA case withdrawn, and I file my second perm within the first 6 months. Within the first 6 months of my second H1 approval. So I've got my H1. I'm trying to remember how we time it. I've got my H1 1 year complete. In the last 6 months of the first year's extension, I immediately file an H1B extension. I've got 1 more year now, but I still have a few months remaining on the first year's H1. In the meantime, I've started recruitment, so I filed my perm application within the last 6 months of my first year's H1 extension, always keeping my second extension based upon the BALCA application in my back pocket. Then what happens is further H1B extensions are given because my perm has been pending more than 1 year. Okay, and if you get confused with
the thing is, I'm not in my sorry.
Yeah, so that's something your lawyers have to time. It has to be timed correctly, but yeah, it shouldn't cause any problems.
Yeah.
Okay.
Even if it is even if I'm in the area of my H1B, it shouldn't create a problem.
No, like I said, I don't care to comment about the details of your case without sitting down and reviewing all the dates, etc. But talk to your lawyers.
Okay.
I already told you the theory of how it is done. Okay.
Okay. Perfect. Thank you
Good
so much
luck.
for your help.
Good luck, sir. Okay. So next question is from EAD-I-485. Employer ABC Corp for the past 10 years. I-140 approved in 2012. And there's a name mistake. The approval notice, H1B approval notice is ABC Corp. I-140 is ABC Inc. instead of ABC Corp. So you have an error in your I-140 approval. I think it should be corrected. And the way you corrected it depends upon who made the error. If the USCIS made the mistake, they should correct it without you having to go through any extended process. But if you or your lawyers made the mistake, it can happen, you have to file a new I-140, which is an amendment, but it's basically a new I-140. So if USCIS made the error, they'll correct it. If you made the error, you have to file I-140 again. I think it should be corrected. *5 if you have a follow-up question, *5. This one is from area code 315. Oh, sorry, I screwed that up. I don't know what I did. 315, can you press *5 again? I'm sorry, I screwed that up. I went directly to 510. Okay. 510, I can hear you. 510, Pennsylvania, I can hear you.
Hi Rajiv, good afternoon.
Good afternoon.
So, I have a similar situation. Actually, one of my priority date, they have messed up.
Okay.
This was due to amendment. My new company, it was a takeover, and then the new company applied for amendment.
Hang on one second. Hang on one second. Let me interrupt you for just one moment. Priority dates are real easy to fix because by law, by statute, you are entitled to your priority date. It should only take one phone call and one letter to fix any priority date issues. Okay?
Okay.
So don't worry about that. That's very easy to fix. Very easy to fix.
Okay, so my lawyer has to send an updated letter, right? Like requesting.
They should call as well as send a letter. If in the meantime your priority date becomes current, they should file the 485 even with the erroneous priority date, as long as they either give a cover letter and preferably an approval notice showing the earlier priority date.
Okay, so I can even use my old priority date copy and then
absolutely.
We should be good.
Absolutely. But I do want your lawyers to correct it. Okay?
Okay. Thanks, Rajiv.
You're welcome. Okay, back to area code 315. Sorry, I messed that up for you. Where are you calling from, 315? Oh, sorry. 315, I can hear you now. 315.
Yeah, I can hear you. Can you hear me, Rajiv?
Yes, I can. Where are you calling from, sir?
Oh, I'm calling from New York.
Okay.
So yeah, I heard your answer. So when I spoke to my employer, right, because before I didn't realize that it will be a problem, but when I spoke to my employer, they said the tax ID and the employment identification number, everything is same. I should not be worried. So do you should I do? Like,
no,
a big concern.
I agree with them that it's nice to have the same employer ID, but the name is still incorrect. It should be corrected.
So my understanding is, if we made the employer made the mistake, then they have to file the amendment to fix it.
Right.
Or if USIS made the mistake, then it is simply the typographic error. They have to correct it, right?
They have to correct it. Absolutely. That's very easy to fix. Okay.
Okay. Amendment means they have to file it everything new.
Everything.
Like new application.
Yeah. An amendment is exactly like a new application.
Okay. Okay. Thank you, Raju.
You're welcome.
I think I got the idea. Thank you very much for the information.
You're welcome. Good luck.
Okay. Yeah.
Okay. So let's see. If we skip this. All right. Now we are back to our normal process. The next question. Yeah, this is another one that's a problem for a lot of people. DSM 918, parents are stuck in India, green card is expiring. They went in October 2019. Their flight was booked for April 4th but was cancelled. And 1 year, their green card will be abandoned and get revoked. That's true. Are there any exceptions being granted? Not so far. Do they need to apply at the local embassy in India for an extension prior to the year? I think that's for the immigrant visa, not for a green card. But what you should do, you should at least have them send an email to the consulate explaining the situation and asking for guidance. Also, keep in mind, you should keep track of the efforts you made to try to get the situation resolved. While your parents are sending out an email, you should also contact your local congressman's office. Have them reach out to the consulate to find out what the consulate suggests should be done. Okay? So, of course, their health is more important than the green card. Green card can be applied again. It's not the end of the world. But there are two things that people do sometimes. And in this case, what would be applicable is something called returning resident permit, or S as in Sam, B as in boy, number 1, SB1 visa. So those visas are given if there's a good explanation why you were outside USA for more than a year and let your green card expire. The consulate can then reissue the green card. It takes them a few months, but they can reissue the green card. *5 if you have a follow-up question, *5. So to summarize, I want you to have your parents or yourself, you can email the consulate, contact your congressman, have the congressman find out what's going on and what to do. At the same time, be prepared to file SB1, returning resident. Okay. *5 if you have a follow-up question, *5. Okay. Next question, USA Desi, posting on behalf of my sister. Sister and brother-in-law are here on L1A and L2, I guess. Son is currently in India. My brother-in-law has received his approved extension for 3 years, and which is now good till April 2022. Sister has not yet received her L2. Nephew has an L2 stamped in 2017, which is good till 2022. But the PED, I don't know, I guess that's petition expiry date, on the stamping is 2020. Can he use that visa? I think he can use that visa because there was no gap in the status of the L1A holder. It's a good question to ask the consulate, but I don't think there should be any problem. I don't think he needs to get the stamping done again. He can come with the new approval of your brother-in-law. Okay. *5 if you have a follow-up question. Okay. From 609, that's I think New Jersey. New Jersey, go ahead, please.
Yeah, thank you, Rajiv. I'm calling from New Jersey.
Mm-hmm.
So the question is, what would be the worst case on a travel?
I'm not worried. Look, this is what I would suggest. If you are concerned about even a bad case and putting this young gentleman through all kinds of nonsense, what you can do is clear customs in the Middle East or clear immigration in the Middle East. So take one of the airlines that clears immigration in Abu Dhabi. That way, if there is a problem, he only has to fly back 3 hours, not 22 hours or 18 hours or whatever.
Yeah, I understand. But I was just looking at
I don't think there's a problem. But if you're uncomfortable, do that. Okay. Good luck.
There's only one last question.
Yeah, go ahead.
Would it impact my L1 at any stage because of this travel?
Not at all.
Thank you, sir.
The sins of your children are not visited upon you.
Yeah. So
okay. Yeah, no worries.
That's it, sir.
No worries.
Thank you, sir.
Good luck, sir. Okay. So the next question, okay, that was a frequently asked question. And this is from Papani04. Not sure what's going on. It's a long fact pattern. Let's see. The priority date is current. Unable to file AOS due to the old company doesn't exist, but the I-140 is active. So really the first thing I would question is, there's nothing wrong with that I-140. It's revocable, but it hasn't been revoked yet. So why can't you use that priority date? And I think there's all kinds of law in your favor if your I-140 is not revoked as of January 17th, 2017. All kinds of law in your favor. So I personally think that I-140 can be used. But have your lawyers take a look at it. And I'm not sure. Current employer perm is expired, recently filed for 3-year H1. I'm not sure what the question is. You can definitely request H1 extensions based upon the I-140 that is already approved. And if the priority date is current, they should give you 1 year. If it is not current, they should give you 3 years. Okay, Pani, too many questions. I'm not sure what I'm answering. I'm kind of lost. Focus your questions a little bit. If you're on the phone, press *5. Press *5. Let's see if we can answer the critical questions for you. Okay. Area code 510. 510. Where are you calling from?
California.
Okay, ma'am. So you begin with the assumption that the I-140 that is already approved, even if the company went out of business, is something that you can use at least for the priority date, maybe even for the H-1B. I think you have some very strong laws favoring that conclusion.
My question is not that. My priority date is current. EB3 priority date is current, but unable to file 485 due to company does not
Okay. I am sorry. I misunderstood. Now I understand. The problem is you don't have a new employer's green card ready to be filed, and the old employer's.
Yes.
Okay, got it. Yeah. You should be able to get not only 1 year. You should be If the dates are current, you should be able to get 1 year extension. No question about it.
But they send a notice with a H1 extension. With this visa number is available and you are maxed out your H1. So you have to demonstrate the visa number is not available. Then only we will give H1 extension like 8 CFR.
Right. I have not reviewed the law very carefully on this issue, and I don't remember the law off the top of my head. But I do remember this, that I think you should be able to get your 1 year extension. You see, as I said in the beginning of this call, I'm not sure you were there, I said there are 2 different sections under which you get H1 extensions. So the one that gets you 1 year extension should still be applicable even if the dates are current. And I'm pretty sure we've done this before. Okay.
Dates are current, but didn't file I-485 also.
We were still able to. I am pretty sure we were able to. But that's a good point. I don't remember if we had filed 485. I think we had already filed 485. So I have to look at the law. I don't remember off the top of my head. but it's an interesting situation where old employer is no longer supportive or they are not in business anymore. New employer doesn't have a green card ready. Dates are current. 485 is not filed. Can I still get 1 year extension? My guess is yes, but I really don't know the law off the top of my head. Okay?
Okay. One more question. We asked one attorney. She told within past 12 months, if the dates are going back and forth, the retrogression, maybe you can request even if you are unable to file. In this 12 months?
I'm not sure that is correct. But if the 1 year is available to you despite not having filed 485, then you have no problem. Have somebody look up the law. It shouldn't take more than a half hour. Okay?
Okay.
Good
Thank
luck.
you so much.
Good luck. Good luck. Okay. Next question. EB1C application, when can the dates be current? Nobody can predict that. Sorry. Next question, member 24. I got a specialty occupation RFE, IT project manager. Just want to get your thoughts on this RFE. Well, that's a very difficult question. It's like asking a doctor, what are the chances of the patient's survival? I don't know what the disease is. So if you just generically ask an open-ended question, I cannot answer that question, sorry. But I'll tell you this, that our situation, because of successful lawsuits, has improved considerably over what it used to be just a year ago. Okay? So if your lawyers do half a competent job, they should be able to get you through. *5, if there's a follow-up question, *5. Okay. Shubh Kumar, I think I already talked with you about this. I have a feeling that you are the same gentleman that I called yesterday. There's a question now a little late. Sit tight, I'll get to you in a second. So the question is, I'm on F1 OPT. My H1B is pending with a change of status request. I don't want to go forward with it. So what I told you was, if you are the same person, Shubh, what I told you was that from what I know, I could be wrong, but from what I know about this situation, once your H1B, quota H1B is filed with a change of status request, at some point, your school is going to revoke your SEVIS. And if the H1 is approved with a change of status, then your OPT is gone according to the government. Although I'll argue that it's not, because there is some strong law favoring a conclusion against that conclusion. But the smart thing to do is this. Have your employer revoke your H1B. The person that I spoke with was already doing that, and they actually had proof of that. There was a letter sent and there was a proof of delivery. I said, take that proof, go to your school and tell them that you don't want your SEVIS to be disturbed, and if they have already revoked it, to reinstate it through a data, they call it, I think, data correct or data fix. Do a data fix on my SEVIS. So that's what I had recommended. Okay. And I think it's the same gentleman. *5, if you have a follow-up question on this. Okay. Let me go to, somebody had their hand up and then it went down. The *5 works like a toggle. When you press it once, your hand goes up. When you press it again, it goes down. So anybody who has a question after I deal with area code 412, get ready to press *5. 412, go ahead, please. Where are you calling from?
Sir, I spoke to you in the morning and the same person who asked this question.
Right. We talked, right? You are the gentleman I called.
Yeah.
Okay.
Yeah. So just one last quick question. You told me to contact with UISCIs regarding this. Do you think I should call them?
Yeah, I think you should. I think you should call and you should make a note of, I told you to make a note of what you told them and what they said. Just have, because tomorrow if I end up in court over this, I want to make sure I've got a strong case for you.
Okay. Sure. So it won't adversely affect my case.
Oh, absolutely not. Why should it? Why should it? It's the truth.
Okay.
Okay. But call your school first. That you should do immediately. Okay.
Yeah, I did. So as of now, my service records are in place.
Oh,
they
good.
told me if there is any update, then yeah, they will let me know.
Good, excellent. Well, good luck to you, sir.
Thank you, sir.
Bye. Okay. Anybody has any question of any kind? Go ahead. Press *5. Oh wow. Oh, there's one. Just 2 questions? Wow, things are slow today. Either people have learned everything they need to learn about immigration law, or no, 3 questions. Okay. All right, 3 questions. Let's begin first with area code 724. 724, where are you calling from?
I'm calling from Virginia.
Yes, sir. Go ahead.
So I'm also on STEM OPT F1 visa. My question is, as everybody's getting stimulus checks, so if in future I want to apply for a green card, or down the line I want to be natural.
Yeah, let me stop you. Let me stop you right there. The stimulus checks that you are getting are based upon you having worked as a U.S. worker. So taking those checks, depositing them, using them, I don't know, buying nice clothes with them, anything is okay. I don't think you will have any problem with your green card.
So there's like public safety fund.
No, this is not a public charge issue. Public charge issue is when you go looking for government assistance. This is being given to everybody who worked in the United States. Okay.
Okay. So there won't be any issue if. So we don't have to return to the IRS, right?
You do not. Okay.
Okay. Thank you.
Good luck. That's it. Area code 203. 203, where are you calling from?
Hi, Rajiv. This is Ram. I'm calling from Virginia.
Yes, sir. Go ahead, Ram.
Yeah. Rajiv, I have a question on my H1 extension beyond 6 years. So my H1 extension is going to expire on mid of Feb next year, and I will get to know my next year extension only in the month of December. And my wife is on also H4 EAD, and she is working on a part-time job. So I just wanted to know if, because I do not have any clarity on the extension for the next year, can I apply, since now it is 6 months since first Feb now? So can I go ahead and apply for extension through my employer, or do I have to wait for my contract extension, basically the contract letter in the month of December?
Well, the problem is the memorandum issued by the government on this issue is itself a little unclear. The memorandum says, well, we won't require any contract documents, etc. normally, but if we want to give you extension for less than 3 years, we just have to explain why. So the net effect is that you still can be asked to produce some proof of the extension or the possibility of extension. Now, if your end client feels comfortable stating in a letter that they expect but are not contractually bound yet to extend your H1 for another 3 years, I think that's sufficient to get you a 3-year extension. Okay. But if they are not comfortable saying that, I think you're taking a chance by asking for an extension, which is not the end of the world.
Okay.
What can they do? They'll just deny it. So what?
Right.
You can extend when you get the contract. So no problem. I would say try it and see how it turns out. It might work out for you.
All right. Thanks, Rajiv. So I can go ahead and apply for the extension like next month onwards,
Yeah.
Since the 6 month period starts now.
Right.
Okay.
Right. Okay. Good luck.
Thanks, Rajiv. Thanks
You're
a lot.
welcome. You're welcome, sir. Okay. And I have the last question is from, this is an old friend in our neighborhood. Good morning. I can hear you. Go ahead, Washington, D.C.
Good afternoon. Thank you so much.
Oh yeah, it's good afternoon.
Yeah,
Thank you. The hours go by so quickly. I think it's like 7 a.m. in the morning. Anyhow, tell me how are you doing, and tell me what can I do for you today.
I'm doing well, and I have a quick question for you around the TN. I'm in the interview process with a company.
Yeah, I remember you. I remember your situation.
Yes.
Yeah.
So my question around the TN is, so I'll be coming in on a TN for management consulting, and the company would like to know your thoughts on if I were to do part-time for the rest of 2020 and then move into full-time in 2021, that arrangement impact the success of getting the TN?
Are you planning to get your TN from the border or from the USCIS?
I was planning on getting it from the border in Toronto. They're only doing it when you fly in and fly out, not at the land border.
You see, there is a Foreign Affairs manual note on this. This is what I would do. Write down this, Christy. Volume 9 Foreign Affairs Manual, and you can just Google it. Section 41.59, Note 11. Okay. Under this particular interpretation of the State Department, which albeit not binding on the USCIS or the CBP, is definitely extremely strongly suggestive of what the law should be. This says that you can, as a TN visa holder, work part-time, but it doesn't say how many hours minimum. That's where good common sense and lawyering comes in. My suggestion to you would be, if the number of hours you work does not produce enough money for you to support yourself, they are not going to give you the TN. Okay. So really, first thing is, we know that it can be for part-time. 2, we know that you might have to produce a budget. I spend $300 on ice cream, $500 on wine, $1,000 on my rent. So you actually have to have a budgetary statement and show that you'll be able to sustain your livelihood based upon the number of hours you work. Okay. If you are able to comfortably meet that test, I think TN is possible. But whenever you have unusual situations, less than full time, there's always a possibility the emperors at the border could turn you back and create problems for you. If you were filing from within the United States, I would have more comfort level because there's room for give and take and arguing. Once you're at the border, they are the emperors and you are the subject.
My concern about filing inside is that just the length of time it may take. Seems like it's taking...
You can do premium, right?
They're pretty backed up.
You can do premium, right? So what's the problem?
Okay.
Yeah, that's what I would do if I were you.
Okay. And then just in terms of timing, the start date is looking like October 1st. Have you heard of anything coming down the pipeline that would be suggestive that I go sooner in terms of any executive orders or anything else?
No, I haven't. Plus, remember, so far, Canadians, being our favorite cousins, have been exempt from all restrictions pretty much.
Okay, great. Thank you so much for your time.
You're very welcome. Good luck to you.
Thank you.
All right, folks. Excellent. I think we're done for today. There's no other questions. I will see you folks again in 2 weeks. Everybody take care. Keep those masks on. Stay safe. Thank you for being here. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.